Hey, time for another JSTV snack. Having a little snack here. We're going to talk about
tea time. I like to call it tea time.
Tea time, snacks,
Yeah,
tea, and some snacks.
JSTV tea. We're spilling the tea.
All righty. Well, we're going to do that.
You like snack time.
I like a little bite. I feel like a little bite, a little appetizer. We're going to talk about the Fitzsimmons case. We wanted to look at the actual order from the SJC. Remember, this is the case in which the SJC was being asked to overturn the lower court, which put Kelsey Fitzsimmons back in jail because she couldn't handle the Scram blood alcohol device and wouldn't consider alternatives. So we saw that the docket announcement was relatively cryptic, and I'm not so sure this is less cryptic. Oh, wait a minute. That's the wrong one. That's yours, isn't it? What is that?
Well, that's mine. But we can do this first. Let's do this first before we do the order. Everyone's been asking how it is that I can't seem to.
There it is.
How it is. There you go.
Okay.
And thanks to Missy Mayhem, we got that to write to Kelsey.
Oh, that's good. Yeah.
The Western Massachusetts Women's Regional Correctional Center, which you have a picture of because you were there in front of it in one of your many trips up to the Triangle of Terror, as you call it, which now may be expanded to
a quadrangle.
Of terror, right?
With Chicopee.
Here is the requirements. All inmate correspondence is open and inspected for contraband, black ink or non-colored pencil. The paper must be white, free of stain spills. It can't include lipstick or perfume or cologne. Just as a little aside, when I get a lot of inmate mail writes to me seeking help, and I could always tell because somehow they've always put cologne on their letters going out. So
that's okay going out, but not coming in.
Especially when it says attorney-client email. Envelopes must be pure white. Drawings must be non-colored pencil or black ink. Greeting cards, non-layered, no pop-ups or music devices. Only two-sided cards with no layers will be allowed. Phew, I can't even know if I can figure that one out. Photographs, I don't know what it means either. Photographs must be in the original form. Any alterations, including glue-like substance, tape, or tears on the photo will not be allowed. And usually photographs are now printed on a piece of paper. Mail received that does not conform to this policy will either be returned to sender, or placed in the inmate property bag until released from the facility.
Blow the dust off of that.
Wow. Or sent to the CIU for investigation. Privileged legal mail is opened by the security staff. This is very important. In the presence of the inmate to check for contraband. So they don't even trust you or I, us lawyers, Michael Bryant.
Don't put a file in there. And the address is at the top, right? Yeah. So that's where you want to write. There's the ID number. There's the Center Street address in Chicopee. So if you want to send something to Kelsey Fitzsimmons following all of those rules, there you go. Now you know how to do it.
And thanks, Missy, for grabbing those.
Yes.
I'm going to remove that from the screen. Whoa, we're both trying to remove it from the screen.
Okay. We're battling the buttons, the control buttons. Okay, so now let me get, that one's still there. How do I get rid of that one? I can't get rid of that one. Somebody else will have to get rid of that one. I'm going to put this one on. I'm going to put this is the actual order from the court, which in a cryptic form was on the docket, but we thought, let's take a look at the real one and see how bad it is. Let's tear into this. Okay, let me zoom in a little bit.
This is actually very important because there's a footnote or two here that
always the footnote
more than the order.
So this matter came before the court Dewar J on the defendant's petition pursuant to GSC.
That J stands for Justice of the Supreme Judicial Court.
Yes, her name's Elizabeth, known as Bessie. The defendant seeks relief from an order of the Essex County Superior Court dated September 11, 2025, vacating a prior order of release. And then we'll get to the footnote, and let's go to that. Contrary to the suggestion in the petition, the judge did not revoke the defendant's bail pursuant to blah, blah, blah. Rather, pursuant to the last sentence of that section, on motion of the defendant, the court reconsidered the bail order and concluded that because of a change in circumstance that had arisen, the defendant's inability to comply without intense pain with in-home Scram alcohol monitoring, a condition of release that the court viewed for reasons stated in the court's order as critical to reasonably assure the safety of another person and the community if the defendant were to be released on home confinement. No conditions would reasonably assure the safety of the named person and the community. Okay. As the Commonwealth notes, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that information exists that it was not known at the time of the hearing, or that there was a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will be reasonably assure the safety of other persons or the community. So this is key. This, to me, is the court, Bessie, telling Tim Bradl, bring this back for reconsideration and focus on a changed circumstance. For example, she can do the scram. That's the changed circumstance. If the court believed she couldn't, and that's why she was put in jail, then bring the motion for reconsideration and bring in as new changed circumstances. She can do it. She can do it, Judge. She will do it, Judge. There will be no problem.
Well, before we talk about the significance of that, let's go back to the actual order itself, okay? Because it also says that the petition is properly before the court, but following close review of defendant's petition and dependent materials, and we're not sure if she listened to the vocality of the judge. That's not technically the record, certified record below. The Commonwealth's opposition and appended materials include a transcript of the hearing held on September 11, 2025, and the judge's orders. This court concludes that the judge did not commit an error of law or otherwise abuse her discretion. Accordingly, the petition is denied without hearing. It doesn't answer the question whether she listened to the tape. It doesn't answer the question. And the sounds and the vehemence and the absolute disdain, which, yes, you can read about it, but hearing it is like, reading a movie script versus going to the movie theater and listening to the movie.
Yep. And I think if she had in fact listened to it, it would have been written that way. But to clearly say that the appended materials included a transcript of the hearing tells me that's all she did. She read the appended materials. Now, from a procedural standpoint, do I have to provide you the audio in some form, or am I prohibited from doing that? Am I limited to the transcript? Remember, this is
Bradl provided it. He provided it. He asked her to listen to it.
And I guess she didn't. And it's a de novo review, meaning she had certainly the opportunity to bring in or look at anything she felt was relevant and appropriate. But why do you say that we looked at the appended materials, including a transcript of the hearing, if you listen to the audio? I don't think you say that.
So going back to now what you suggested, this says to Bradl, there's a changed circumstance that Kelsey can now actually blow into the scram, and she hadn't violated the scram order before. That's what gets me.
Well, this
is what gets me. And she can now comply with that condition of bail. But the whole point was that it was painful, so they were trying to get the condition of bail changed. She didn't violate anything, and this suggests
that's what is so frustrating about it, and that's what makes it look like this judge, the evil McCarthy, was that she was just looking for a reason to put her back in jail, that she never considered the fact that it was painful and they wanted a condition change as willful noncompliance. There was never noncompliance. As the parole officer January said, there was never noncompliance. But the judge found what the judge wanted to find to throw her back in jail. So what Bessie is doing here is trying to help.
Or justice Duar for you.
Yes, that last sentence. As the Commonwealth notes, nothing prevents the defendant. Can I highlight that here while I'm on the fly?
Oh, wow. You are good.
As the Commonwealth notes, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that, get this.
I need another lesson.
Yeah. Information exists that was not known at the time of the hearing, or that there was a change in circumstances. Okay, we can't argue that it was not known at the time of the hearing, right?
Right, because it was known at the time of the hearing that she complied. It was known at the time of the hearing.
Yeah. So the change in circumstances has to be that she now, whether it's because she is willing to do it or can physically do it, however you want to couch that, Tim Bradl, the change in circumstances is that she is now fully able to comply with the prior scram condition of release.
But that's what only puts her back to where she was
Well,
beforehand.
don't you think she would take that? Would she
Oh
take
yeah,
that?
I think right now you have to take it. But
Yes.
then what happens is it's going to lead to her one of these times, because she still has those bullet fragments, she's still not healed, not being able to comply with that condition, being in great pain, but let's just say her doctor puts her in the hospital and says you have to go to the hospital because you're those bullet fragments, because of what you're doing, about to have some issues there. Then she's in violation, and this judge can put her right back. This is just a setup.
I think, in this case, who knows what might happen and what this judge might do. But I think you got to take baby steps and small victories as you can get them. She, I think, will take that to get out of jail, to deal with the pain, to minimize it as best she can, to comply, and just be out. I would think that's preferable to what I think is a life-threatening situation, being in jail as a cop and a former correctional officer. So we'll see. I'm going to reach out to Tim Bradl and tell him to put me on the payroll. I'm going to help walk him through this changed circumstances argument. I think it's the best way to go, and I think the court is telling him on behalf of his client to do this, to make this application.
In the meantime, make your habeas petition to the federal courts with the ADA.
I think that the justice is also telling the court that this could be coming, and if it is, maybe you should be a little more receptive to it. Just my thought.
Okay, so maybe there's all these behind-the-scenes phone calls going on too, and I have a feeling that maybe the probation department has been meeting with the head judge in that area to say, "Hey, wait a second, you just I don't want to say that word, but you kind of shall we say put
neutered." You neutered it?
Let's use that. They neutered our whole probation department. And we want to have a discussion with the chief assignment judge, whoever that is for the lower court here, to say, hey, there's got to be some parameters here, because I'm not putting my people, into your courtroom, any of your courtrooms, if they're going to get treated like this.
Yeah. I think that's the least they should do, is be able to get that understanding that these probation folks know what the hell they're doing. If they're in here testifying, give them some credit that they know what they're doing better than you do. Oh no, compliance, that's my decision, says Judge McCarthy. No, it's not. You can take that opinion and agree or disagree, but it's not your call. He's the one who determines compliance or non-compliance. You get to decide whether that affects the release conditions for the bail. So, okay. Obviously, we're going to be continuing to drape ourselves in this case. We heard there may be a standout that they're in the works on doing, so we'll keep you posted on that. Okay. All right then. Hey, Michael Bryant here, Linda Kenny Bodden there. This is Justice
Share, like,
TV,
subscribe,
and write comments and share and do all those things, and then of course try to do the right thing.